May it please the court, my name is Wisotsky on behalf of the petitioner Miguel Exposito. There are two issues before the court, and they are not difficult issues. The first issue is the question of whether demotions took place when the chief reassigned laterally 3 members of his senior command staff. The second question is whether the city violated the mandate of the 5-day mandate of its charter, the 5 days being to hear and adjudicate the case before it. The court question for both writs that we seek, the writ of certiorari and the writ of quo warranto, there's an overlap between them. And the core question in both cases is whether the city acted lawfully or not in its termination of the chief. We submit that the record shows that the city acted unlawfully on both grounds, both the for-cause requirement and the 5-day requirement. The story that culminates in the suspension of the chief takes place in 4 days in August 2011. And I think it will help the court if I give a very brief synopsis of what happened on those 4 days. On August the 1st, the chief met with the city manager. He asked for permission to roll back 3 members of the senior command staff to their civil service positions. These rollbacks are common. The senior staff serves at the will of the chief. They are his inner circle, his most trusted confidants. And the maximum civil service rank is that of captain. So we're talking about people with a rank beyond that, but it's a discretionary rank held at the will of the chief. The city manager approved. Then, on a follow-up meeting on August the 4th, the city manager, having learned the identities of the 3 proposed to be rolled back, advised the chief that he had changed his mind and told him to hold off on the demotions. He then put it in writing to the director of employee relations, Beverly Pruitt. Beverly, please hold off on these demotions with a copy to the chief. So the city manager had changed his position. Now, the next day, the chief sent what I would fairly characterize as a heads-up email to the city manager saying, I acknowledge the restrictions that you have placed on me, and in order to comply with those restrictions, I'm going to make some other changes with regard to this staff, the senior staff that we discussed. Silence followed that email. That was August 5. The chief was waiting for a response that, no, you can't do that, or perhaps you modify it or something of that nature. There was no response on the 5th, nor on the 6th, nor on the 7th. Now, the chief is about to leave on a 2-week vacation on August the 8th, and he's concerned about the impact on police department operations of leaving the 3 men in their positions. Why is he concerned? 2 of them were the subject of law enforcement investigations by outside law enforcement agencies. And the 3rd one had committed a major blunder in the budgeting process to the tune of a $2 million shortfall that turned out not to be an actual shortfall, but caused great embarrassment to the chief and to the department as a whole before the city commission when it was presented. So on August the 8th, the chief felt that he had to take action, and he did. He made the reassignments to other duties of these 3 senior command officers, leaving to the acting chief, Chief Blom, the responsibility to find appropriate positions for them. And Chief Blom testified that he ordered that these 3 senior men be treated with dignity and respect, and to be given positions, duties commensurate with their rank and experience. Now, 4 weeks go by from the August 8th reassignment. There is no pushback from the city manager. There is no questioning by the city manager. There is no calling on the carpet by the city manager. The chief assumed that all was well. On September 6, 2011, however, he received the notice of suspension from the city manager. Under the city charter, once a notice of suspension has been issued, the city must convene as a quasi-judicial body to hear the charges and decide the charges within 5 days the charges filed by the city manager. Very briefly, the charges were twofold. One is the question of the demotions, which I have previously described. The second was a budgeting / overtime issue, which is no longer part of the case because the city commission found in favor of the chief on that ground. So the only ground then is the ground of the question whether these lateral reassignments, preserving their rank, preserving their pay, preserving their benefits, constitutes a demotion. Well, in addressing this question, I asked the court to take note that the city charter is something like the U.S. Constitution for the city. It's its governing document. It creates a government structure, a governance process, and a system of checks and balances. So the city, in its pleadings, has spilled a lot of ink over an issue that is not an issue. We do not contest that the city manager is the chief executive officer of the city. We do not contest that the chief of police serves subject to his authority. But there are two important limitations in the charter on what can be done to a police chief. A chief of police.
Either.
Yes. So one important restriction is that the chief cannot be removed except for cause. He is not an at-will employee. He can only be removed for cause. And second is the 5-day restriction. The charter regards the position of chief of police as so important that when there is a suspension, it does not allow for any hiatus in leadership longer than 5 days. So, let me turn now to the first question of whether there were demotions. And the short answer to that is no. Because the city code, section 40-61, defines a demotion as a reduction in classification and status, in the conjunctive, classification and status. The city manager himself conceded at the commission hearing that there was no demotion under that test. And I quote from page 12 of the transcript, the full transcript filed by the city. Quote, technically, did Miguel Exposito demote the 2 commanders and assistant chief? No. They still have the same paycheck. They still have the same job classification. It seems to me that once you admit that, the case is over. That if this were a civil trial, a motion for directed verdict should have been granted. There can be no competent substantial evidence of a demotion for the simple reason that there was no demotion.
Could a demotion not be limited to only reduced pay? Could it include removal of responsibilities or prestige?
It could under a different definition, but not under the city code. The code.
Well, does it define it?
Excuse me?
Is that in there? Is that specifically defined that way?
4061 says that it defines a demotion as a classification in, as a reduction in classification and status in the conjunctive. It does not speak to lateral reassignment. It does not speak to the question of changing duties. Now, something, just as...
So their job titles and salaries were not affected?
Correct. They were, they went over as commanders and they stayed as commanders. 2 of them, and the third one was an assistant chief, and his salary, his rank was not affected. This is part of the city of the chief's managerial discretion on how to deploy his senior staff. Now, the city manager argued at the commission hearing that this was a violation of the, quote, spirit and intent of the order. But I'll tell you, 3 times he used the phrase, hold off on demotions. Once, when he told it orally to the chief. Second, when he put it in writing in the email to Beverly Pruitt, the Director of Employee Relations. And third, in the very charging document, the charging document of September 6th, notifying the chief that he was suspended. It doesn't say he violated the spirit and intent. It doesn't say he was charged to keep the status quo or freeze the status quo. That was never done. It was not done as a matter of fact, and it's not done in the charging documents or the documents that were used against him at the commission hearing. So I would say that this is a relatively easy issue to dispose of. There was no demotion, therefore the writ should issue. The second issue is the question of the 5-day mandate of the city charter. What the charter says is that once a notice of suspension has been issued, the commission within 5 days, quote, shall proceed to hear such charges and render judgment thereon. It's like a speedy trial rule with an extra kick to it in that not only the commencement of the proceeding must be within 5 days, but the completion of the proceeding. The language is quite clear on that point. There was no disagreement at the city commission that 5 days means 5 days. There was, for example, when they convened on September 9th, a lot of discussion about whether they could continue the hearing until a later time. One commissioner said, really, we should deal with the budget. The budget issue is coming up. Another commissioner said, there are possible terrorist threats. We've received information about that. The timing is not good. Yet the consensus, clear consensus emerged from the commissioners and from the city attorney that 5 days means 5 days. Commissioner Sarnoff, an attorney, said, in his opinion, the 5 days was, quote, jurisdictional. Commissioner Suarez, also an attorney, and one who voted against the chief on the merits, said also on the 5 days, I think the chief could go into court and be reinstated automatically under Bryan versus Landis, which is the Florida Supreme Court case cited in our petition. Even the city attorney, although trying to create a little wiggle room, said that the charter, quote, the charter is very clear and it speaks to a compelling time frame, close quote. She went on to say that for a bona fide emergency, such as a hurricane warning, for example, that perhaps the 5 days there would be an exception to it. We don't need to litigate whether there are any exceptions to the 5-day rule because there was, in fact, no hurricane or other exigency. What happened was that the city commission started meeting on September the 9th, went to the early hours of September the 10th, and then, having heard all the testimony and meeting only to hear closing argument and then make a decision, decided and debated whether to reconvene later that day, Saturday, or come back the next day, September 11th, but instead it chose to take a 2-day recess until September the 12th. They did this over the vigorous objection of counsel for the chief, and I think it's fair to say that the city knowingly, willfully, and intentionally violated the 5-day rule. They were not forced to do it, they chose to do it.
Clearly, it's your position, Mr. Wisotsky, that your client need not show prejudice.
Just as with the speedy trial rule, you would not show prejudice.
No. Under 3.191 or under the constitutional speedy trial?
Under 3.191A. So there's no prejudice need to be shown. This rule, it sounds like a very technical thing. Anytime you have a number, it seems very technical. But rules are rules. The President of the United States has to be 35 years old. 34 and a half is not good enough. And the same thing, I think, is true with this 5 days. The 5 days has a purpose behind it. It's a protection not only of the chief, which is another reason why prejudice need not be shown, but a protection of the public. The public has a right to have continuity in the public safety department, in the police department, so that it's not left hanging, it's not in limbo with the fate of the chief left unresolved. So I think under Bryan versus Landis, by the way, which was a case against the city of Miami for violating the 5-day rule, the writ did issue the writ of quo warranto, and the petitioner was reinstated. And we seek similar relief